Hello friends, in this video I am going to discuss what to do if your employer terminates you without giving any reason. Termination of an employee in a private sector and corporate sector is a common phenomenon. Many of the employers terminate their employees by legal means and by the contract as they have made while they appointing that person. However, many of the employers terminate their employees by illegal means. So in this video, we will discuss the employee's rights if she is terminated illegally or without any reason. However, before discussing the rights of an employee, let's first understand what are the category of employment. There are normally two categories of employees, namely workman and non-workman, that is white-collar employee. The term workman has been defined in the Industrial Disputes Act 1947 as all persons employed in any industry, but it doesn't include an employee who is in a managerial, administrative or supervisory role. Apart from the definition under the Industrial Disputes Act, there is no set formula to distinguish between a workman and a non-workman, and the position has been tested and established through various judgments, depending upon the nature of work being carried out by an employee. Now, let's discuss on what grounds an employer can terminate his employee. Following are the reasonable grounds on which an employer can terminate his employee. Misconduct. On the ground of misconduct, an employer can terminate his employee. However, in such a condition, the employer has to give a reasonable opportunity to put forth his defense. Secondly, the termination process should be conducted in a fair manner. Next, winding up the company. If a company lost its business and have no work, in such a case, an employer can terminate his employee. Next, retrenchment. Normally, industry does with the purpose of cost cutting. However, as defined in Industrial Disputes Act 1947, an employer who proposes to retrench his workman who has been continuously employed for more than 1 year must give 1 month's notice, together with the reason for the retrenchment, or pay in lieu of such notice to the workman. In addition to this, the employer must also inform the local labor authorities of the retrenchment within a stipulated time frame. However, every state in India also has their own legislation relating to labor laws under the provision of the Shops and Establishment Act, which also contains provisions for notice of termination of the employee either with or without cause. Now let's discuss what are the rights of terminated employee. In a case, if you are being terminated as per the law, then the employer is required to clear your all dues which are payable to you at the time of the termination. However, let's check out the legal means of termination. That is, you must be given notice period as per the law of your state. That is, according to the Shops and Establishment Act of your state. If notice period is not given, then the salary of equal days. The salary of the days you worked and yet to be paid. The payment of gratuity in case if you completed at least 5 years of your employment successfully. However, it is applicable only for those employers who have 10 or more employees. So, if your employer has less than 10 employees, in such a case, payment of gratuity is not applicable. If applicable, then the leave encashment for the leaves accrued. Next, retrenchment compensation if the employee is a workman and his services have been retrenched. Any such other dues that employer is liable to pay because of the agreed contract between the employer and the employee, or is payable under the employer's company policies. And the employer also has to assist the employee in making applications to the appropriate authority for withdrawal of the provident fund dues. These are the rules and process. However, based on above given information, if you feel that you are terminated illegally and your rights are violated and you are not being paid your dues, you may contact us on given detail. Our lawyers will happy to assist you.